The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain pretrial settlement conferences. So a pretrial settlement conference is a meeting between the judge and the attorney for each party and the parties themselves for the purpose of settling a case prior to going to trial so that the parties don't have to bear the expense of a trial. The conference usually occurs after all discovery has been conducted. So it's usually once all the facts are on the table, depositions have happened, right before trial happens. But a pretrial settlement conference can occur at any time in the case. The judge can order it very early in the case, or the parties can request it and agree to conduct one very early in the case if it seems like the type of case that should settle early. So at any time that the parties think a facilitation of settlement would be helpful, the parties can have a pretrial settlement conference. And it doesn't have to happen only once in the case. It can happen multiple times if the parties think it will be fruitful. So let's talk about what to expect from a pretrial settlement conference. Again, these usually occur in the courthouse, and the negotiations happen in the judge's chambers. Usually all the parties will show up and wait in the courtroom, and then the judge will call each attorney back separately, sometimes with their client with them too. And the judge and the attorney and the client will all go back to the judge's chambers while the other side waits back in the courtroom. And the judge will basically hear the attorney's statement of the case, their theory of the case, why they think they have a good case, and what their settlement position is, what they'd be willing to offer or accept in settlement. So the judge will do this with both parties, and then after that, the judge will start working on each party or attorney individually. And usually this is with the parties in the room, because what the judge will do is basically say, I've heard both sides of the case, I've heard what everyone's settlement position is, here's all the weaknesses in your case and why it's risky for you to go to trial in particular, and here's what a reasonable settlement would be for you. Can we get you to come closer to this reasonable settlement amount? So hearing the weaknesses of your case from the judge often spurs parties to be more interested in settling, and the judge is never going to tell someone, hey, you've got a slam dunk case, you should definitely go to trial, because the purpose of a pretrial settlement conference is to get the case to settle. The judge wants the case off his or her docket and not clogging up his or her schedule. The parties should want to settle, because if they can reach a settlement that's generally favorable to everybody involved, then they won't have to bear the expense of litigation and attorney's fees. So why are pretrial settlement conferences helpful in settling a case? The reason these work so effectively, one, is real-time communication between the parties. When you're not in the same room together or the same physical location, you are playing a four-way game of telephone when doing settlement negotiations. The party has to tell their attorney what their settlement position is. The attorney relays that to the other attorney, who relays it back to the other party, and then it goes back across the chain. And you can wait a week or two before getting a response to a settlement offer. So it's hard to get really creative. Sometimes it's not just dollar amounts that we're talking about for settlement. Sometimes it is finding creative solutions to problems, and it's hard to do that when the parties aren't all communicating in real time. The second reason that it's helpful is that for many people, they just want to have a chance to be heard by the judge. They have a grievance, they want it heard, and they can tell the judge their side of the story here. And then the judge can tell them, why that is not worth going to trial over. But sometimes getting heard by the judge is enough to make them feel vindicated and make them more reasonable about settlement. A third reason that this is really important, and this is probably the most effective reason, is that for parties who are being stubborn about settlement, and this is not usually the case for insurance companies or more sophisticated parties, but for individual plaintiffs and defendants, hearing from the judge why it's risky for you to go to trial, all the weaknesses of your case, and what is actually a reasonable settlement offer is a lot different from hearing that from your attorney. So that sometimes carries some more weight, and it can convince parties to be more reasonable about settlement. Finally, even if the case doesn't settle in the pretrial settlement conference, because it's usually only a 1 to 3 hour process, if the parties can't actually conclude a settlement, it moves the ball forward on settlement and makes it easier for the attorneys to settle the case after the settlement conference, because both sides know each other's positions. You've had that chance to kind of flesh out where you stand on settlement, and it makes it easier for the attorneys to close the gap later on. So let's finally talk about the differences between a pretrial settlement conference and a mediation. In both a pretrial settlement conference and a mediation, you have a third party trained to facilitate the settlement of a case. In a settlement conference, it's the judge. In a mediation, it's usually a retired judge or a lawyer that's trained as a mediator. The big difference is that you pay the mediator. You don't have to pay the judge, but you have to pay the mediator for their time, so there's an extra expense with mediation. Mediations can go a lot longer than pretrial settlement conferences. They're not constrained by the judge's court schedule, so the mediator will spend as much time on the case as necessary in order to reach a settlement, and the mediator can also tend to be a lot more creative and flexible in the way that settlements are structured. If we're just talking dollars, then there's not a big difference, but if we're talking about sale of real estate or something that one party actually has to do other than pay money, the mediator can help structure a more creative settlement than the judge is usually willing to do. For that reason, because it's a bigger process, it's more expensive, we usually try pretrial settlement first to see if we can get the judge to settle the case. And if the judge isn't able to do that, mediation will often be the next step. Except in certain family law cases, mediation is automatically required. But in civil litigation, mediation is kind of a secondary step after pretrial settlement. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below our video on our YouTube station. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud. That way you'll be notified of our daily article and video posts that we make. We do a different article and video topic every day, and you can find out what we're posting about. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.